Hello, everybody. I had court the other day. Had back-to-back hearings. One was a dismissal hearing for dismissing the disorderly conduct charge over repeated and ongoing violation of the rules of evidence by the district attorney's office. And the other one was a bill of particulars, a hearing on a bill of particulars, which, if the court orders it, makes the DA have to clearly spell out what the charge is based on, and so they can't just throw a bunch of spaghetti at the wall, a bunch of facts that make you look bad and say something in there is a crime, adds up to disorderly conduct, even though none of the things themselves are illegal, that kind of thing. I'm hoping to get an audio recording of the proceedings, but I haven't done that yet, and in the meantime, I have a summary. So first, of course, the first thing the judge did, this is a different judge than the last hearings. This is a Judge Larson, who's appeared or presided over several times I've appeared on this case and the related cases. And the first thing he brought up was self-representation again, and they're just not going to let it go. They really don't like me just proceeding completely pro se. And what he said is the court is trying to find somebody who's available and willing to advise me, work like in an advisory role, supposed to represent me. And so I agreed to talk to whoever the court finds and then take it from there. And at this point, even if it's a public pretender, they'll be useful because, and they can't undermine me in quite the same way, because now I have access to the discovery, and I've downloaded most of what I need, important stuff. Even if they cut me off after my, this attorney comes on board, if the DA's office tried to, say no more evidence for you, that won't be a huge issue. And a lot of procedural stuff like these hearings, it's important to have them, even if cases don't get dismissed and stuff like that. And I've done all that and can continue to do that, actually, if I don't rely on whatever lawyer to do it for me, and expect them to. I can just do it myself. So it'll be different. And I could really use help with the procedural kinds of things, like jury selection, and when it comes to trial, not so much the arguments for why I'm not guilty, but just the procedures, that kind of thing. What comes first, next, how the order of, all that stuff. How to object in the right way. Some of that stuff is available online. Some of it's not. Some of it's specific to Maine, so even what's available online doesn't necessarily apply. Anyway, so I agreed to do that, like I said, and the judge also said he was going to continue everything until October. The next session of they group jury selection and trials together in sessions, I think they call them, and he put it off till the next one, which is starting in early October. So that gives me another 3 months, and I didn't object to that because I'd rather have a fair trial than I would have a speedy trial. I mean, ideally it would be both, but I'd rather, of the two, if I had to choose, and it sort of seems like I do in a way, I'd rather have the fair trial. So that got settled, I guess, for now. Pending whoever they find, for me to possibly work with. So that was settled, and then the dismissal hearing over the failure of the DA to follow the rules of evidence started, and I kind of got to tell part of the backstory as it relates to the evidence, because with some of the evidence they're not complying with. They haven't complied with everything all along. They've broken every single rule of evidence there is, literally. And that's not even a joke. And they're still out of compliance with certain information relating to incidents which are not directly related to the case, which happened before. And so I had to got to tell the backstory of some, like the rights violations and you know, the victim blaming and being mobbed in the park by the crowd while the cops stood by and just watched in Belfast, that kind of thing. And by way of saying, you know, this is why I need this evidence, because this my side of the story is not that, you know, is there's this whole thing there. This is just revenge for me, you know, exposing their victim blaming and rights violations and stuff. And the DA objected to it, but the reason, what he said was that bringing up the past cases would only serve to confuse the jury, which is pretty ironic, because what he is doing is trying to, you know, spaghetti at the wall. That's his whole strategy, is to try to confuse the jury into thinking, well, maybe he might be guilty of something, and he did all these things that they think are bad, and maybe it adds up to a crime. And I mean, that's his whole strategy. And you know, he's supposed to be, I'm supposed to be confusing the jury. He's supposed to be trying to prove things beyond a reasonable doubt. I'm supposed to be introducing that doubt. So it's just ironic and funny. But anyway, yeah, so the judge overruled that, didn't bite either, and officially ordered the DA to comply with the rules. And the really positive upshot of that, the main upshot of it really, is that I will be able to tell my side of the story. I can bring all that stuff is now admissible. It's been sort of officially admitted through that process. I can bring it up at trial. The DA would have to work really, really hard to get it suppressed now, and he obviously doesn't want me to bring it up. So that was a win on my side. But there were no other negative consequences. The DA just has to comply with the rules now going forward. The judge didn't dismiss. He said he wasn't going to dismiss it, and he said the court really can't dismiss cases. It was the reason he gave why he wasn't going to dismiss it. And it says, I mean, in the motion, I mean, we were at a dismissal hearing, a hearing for dismissal before the court. It says right in the rules, main rules of criminal procedure, and I quoted it in the statutes, the reason I was granted the hearing. It says if the violations by the state, the court can impose any number of sanctions, including forcing them to comply, which is the least about they can do, and that's what the judge did. But it goes up to and including dismissing the case with or without prejudice. It says it black and white right in the rule. I didn't bring this up to the judge, but I mean, of course they can. It's like, you know, it's like qualified immunity or something around here. They just, all the judges have gotten together and decided, well, we really can't dismiss cases, even though it says we can in the main rules, and there's all these ways to get dismissal hearings and statutes about it, but we just can't do it. You know, I guess. I don't know. It's anyway. He didn't dismiss it, but it was still kind of a win for me. You know, I still don't think this case is going to go to court, to trial. So, you know, and if it does, now it's been disabled that much more. I'm going to get a fair trial for sure as a result of that. And then finally there was the Bill of Particulars hearing, and basically I made the anti-spaghetti on the wall argument, because that's what a Bill of Particulars is. You know, if you know, they have to specify what the charge is based on, you know, what did you actually do that constitutes a violation of law, not just here's a big list of stuff. Something he obviously did something wrong, Your Honor, or jury, members of the jury. And I pointed out that the facts aren't really in dispute. There are some, you know, things that I would characterize as exaggerations and would dispute, but they're not statements of fact. They're, you know, just vague statements, things like that. And the judge questioned me about it, and then questioned the DA a bit, and went back and forth, and eventually the DA referred to the witness statements as kind of, that's what I'm sort of based on. And I sort of, you know, the exact same the things I characterize as exaggerations. And I flipped open the police report and looked at and found a statement by Dan Rock where he says, quote, I feel like he was being physically and verbally aggressive to my customers, end quote. And I read that and I said, so, his feeling that that's what you consider a fact that I'm supposed to defend myself against here. And he said, yes. We replied in the affirmative. And, well, the judge agreed that also that a bill of particulars was in order and would order the DA to produce one. And plus, he requested a copy of the police report. He didn't have one. I was the only one in the room who had a copy of the police report, and he had to borrow mine. The judge borrowed mine while he was questioning us and was kind of flipping through it. But yeah, he said the DA has to produce a bill of particulars, provide the court with a copy of the police report, which I guess somehow didn't happen or something. And then he also asked me if I wanted anything else to be considered. And I said, yeah, well, there's this motion in limine, which is like a motion to suppress, sort of. What I did is I asked for the particular phrase, quote, Belfast has victim-blaming criminal cunt police, and if the Swan villain gets no justice, then Belfast gets no fucking peace, end quote, be excluded as evidence of a crime because it is clear, per se, because it is clearly political speech at prior permission. It's not fighting words, like that. And so that's the argument there. So he's going to consider that, which he would have been considered anyway at some point before trial, but he's going to consider it now. And then also, I mentioned a motion to dismiss based on lack of elements, lack of probable cause. Basically, I didn't do anything that actually constitutes a violation of this statute. Point by point. And so there's not even probable cause to arrest me, let alone cause to charge me. And I tried to introduce that, but because my attorney Toothaker that I had on board for a little while screwed me over and wouldn't introduce that. It never got introduced. I tried to introduce it myself, but by then it was too late. But now, but as of then, I said, can you consider that? And he said, yeah. And I had to give it to the DA. But I would have done that anyway. But now that's been officially introduced as well. So, and all this stuff is really good to have. If nothing else, if you have to get like a review by the law court, which is a sort of review process here in Maine, or you actually have to appeal or any of that, it's really good to have all this stuff, on the record and admitted. So another, win for me, even though the case was not dismissed. I get the bill of particulars and that dismissal on the record now. And so, yeah, again, didn't get dismissed, which would have been the ideal outcome, but it got damaged, I think, perhaps even, it was already a horrible, they didn't have any case, it was, probably wasn't going to trial anyway. Now it's going to be just even that much harder, so. And it was interesting. I learned, I wasn't as prepared as I should have been to present the oral arguments. I had the paper work and stuff all done, but I hadn't prepared a solid, but I was able to wing it well enough, obviously, to get basically everything I could. I think I got everything, since the court basically can't dismiss cases for whatever reason. I guess I got everything I could get out of it. Thanks for bearing witness and all that fun stuff, and keep fighting. Peace. I'll keep you posted, I guess. And thanks for everything, all the support and watching.